Webinars by intellectuals bring in exquisite knowledge and enhances the parameters to think over the subject. With the same thought, I, Apurva Agarwal, social media and PR head on behalf of Legal Patra team, welcomes you all to the second national webinar on Bureau of Indian Standard Schemes and Trial Proceedings by Advocate Bhagyodaya Mishra. I hereby welcome Sir to our national webinar. I am honored to introduce Sir with our participants, and I am equally honored to present a quick introduction about him. Advocate Bhagyodaya Mishra is an advocate in Gujarat High Court and Supreme Court of India. Sir is an enforcement of Department Special Public Prosecutor, Government of India and Anti-Corruption Special Public Prosecutor, Government of Gujarat. He has appeared in a number of landmark judgments and has been standing counsel in the matters of RBI, ONGC, IRTC, BIS, Allahabad Bank, the National Small Industries Corporation Limited, BSNL, IIM. Sir also has 22 years of experience and he is a life member of High Court Association, Supreme Court Bar Association, American Bar Association, and believe me, the list goes on. As I go through his achievements, I am becoming firm of the fact that could we actually get a better person besides him for this webinar? I believe the answer for it would be no. Hence, without wasting any more time, I would let Sir to take over and shall continue with the webinar. Thank you.
Good afternoon to all. Well, all the participants, good afternoon. Welcome to the Bureau of Indian Standard webinar. What a BIS, Bureau of Indian Standard, that I have to clear all of you. Section 33, 14, 15, 6, 8, 29, 17, 16 by 2. 29 is a mean 29 is a main sections is there. Under that, penalty is there by the court. Metropolitan Magistrate of the first class pass the order. Maximum 5 lakh rupees is there. Earlier it is less. The new amendment has been made in 2018. Then afterward 5 lakh rupees are maximum imposed. If wrong ISI will be used or it has been not been registered with the ISI. Bureau, what the BIS done? BIS given the ISI license. Those who are manufacturing, those who are trading, or they are manufacturing, most probably manufacturers such as gold, water, and different products who's taking the ISI registration. They are only the concerned person to use the ISI mark. Otherwise, those who are not have a license and they misusing and the wrong ISI mark done. So at that time, BIS, Bureau of Indian Standard, take the investigation against them, seize the goods, items, and then after file the police complaint also, and also file before the court also, Metropolitan Magistrate of the first class. In appeal 13, 14, 16, 18, 13, 14, 17, 18, 7, 27, 7 and 8. These all are for appeal moving go before the consult court. Now I will start what is the Bureau of Indian Standard. I will telling you about that. Now you can concept has been clear to all of you. What is the Bureau of Standard? What Bureau of Standard is doing? I just now the sections are there only that I tell you of the BIS. BIS, now what the function of BIS, how the BIS has been working under Ministry of Food Processing, how the department has conducted their work and how the investigation has been done and what the penalties are there, how the section has been implemented. These all the things I will tell you in this webinar. Please with me. I'll later onward I'll tell you one on one in all the process and of the BIS. Now the BIS is a act. BIS has been registered. Earlier, his amendment has been made in BIS. GSR 584E in excess of the power conferred by Section 38 of the Bureau of Indian Standard Act 2016, bracket 11 of 2016, and in supervision of the Bureau of Indian Standard Rule 1987, in so far for the relevant chapter 4A of the said rule, and in the supervision of the Bureau of Indian Standard Rule 2017, except and respecting done by omitted to be done before such supervision, central government hereby make the following rule. This rule may be called the Bureau of Indian Standard Rule 2018. The rules, unless content otherwise required, A. Act means the Bureau of Indian Standards 2016, 11 or 2016. Advisory committee means the advisory committee constituted by the Government Council, subsection 1, section 5 of the Act. Certificate of the conformity means granted by the Bureau of Designation Authority, demonstrating that the articles, process, system, service has been determined to be compliance with the standard or specify requirement following assessment of the conformity. D. Consultant means an expert organization or expert engaged for a specific tax related to the standard formulation of whom a fee is payable by the Bureau. Director General of Bureau means a form appended to this rule, license being the person whom the license has been granted under this Act. Technical committee also be decided by the ministry, and the committee will be amendment. Any rules are there? Not a rules. Any development has to be made. That work has been done by the committee. Relative to the complaint has been given by the party or any NGOs, any outsources. So in that also they done the work. Technical means the committee constituted by the Bureau under subsection 3, section 10 Act, and included division, council, section committee, subcommittee, panel, working group of other committees. Board then express use this rule that defined in the Act shall have the meaning respectively assigned by them. Constitute of the Government Council. How the Government Council has been appointed by the BIS, it is there. The ministry in charge of the Ministry or Department of the Central Government having administrative control of Bureau, who will be ex-officer or president of the Bureau. The Minister of State or Deputy Minister, if any, Minister of the Department of the Central Government having administrative control of the Bureau shall be ex-officio Vice President of the Bureau, and there is no such Ministry of the State. Deputy Minister of such person as may be nominated by the Central Government to be Vice President of the Bureau. They all are the committee members. The Secretary of the Government of India in charge of the Ministry of Department of the Central Government having administrative control of the Bureau, ex-officio. Director General of the Bureau, ex-officio. The two members of the Parliament whom shall be from the House of the People and other Council of State. Two Parliament members also be one of the committee members. 7 and 8 people are there in the committee. Is one NGO also and by the ministry, by the MP. In this way, the 7 and 8 members are there. They are deciding if any changes have to be done, any complaint has been come before the BIS. Such type of day-to-day complaints or day-to-day any developments have to be done. Within 2 months or 3 months, such meetings have been there in the department. 5 representatives of each 5 zone of the state government of the union territory basic of salary. The minister in charge, secretary of the department having administrative control over the quality and standard of the case stated in union territory having the council of this minister. Administrator of the chief executive councillor, as the case may be in the case of union territory not having the council of minister, 2 persons represent consumer organization NGO, which is obtained to the central government active to the effective their operation or in the option of that government are capable to represent consumer interest. One person who is opinion of central government capable to represent former interested. 5% represent the industry and trade of their association and public sector enterprises chosen as the following. President of the Director General, Secretary General of 3 industry association of Federation all India level. Chief Executive 1 central or state public sector enterprise related to the subject to the importance of this bureau. Third, Chairman of the Managing Director of one industries organization other than the public sector who is an awardee and the nation or an international award of the quality. 3% represent scientific and research institute, technical education and professional organization that subject of the importance of the bureau. 1% represent regulatory authority or body dealing with the important subject of interest of the bureau. Term and office of the member shall be continued so long as he holds the office by virtue of which he is such a manner. The government council may be associate person now exceeding 15 or assist of the advisor in the field of science or technology, including environment, control, energy, conservation, important substitutions, transfer of technology, and other area of emergency technology. Term of the office of the member. Member appointment under the clause E or to the clause M, subsection 1, subsection 3 shall be hold office for the period of 2 years and shall be eligible to reappointment. Their appointment for the 2 years and most probably they are reappointment, but sometimes some new officer, new members are also be joined before the organization. Member of these are all the things. Third, when the vacancy occur, a registered member under subsection 2. Otherwise, central government shall take the step to fill the vacancy within a period of 6 months from date of its occurrence by making appointment of and from amongst the category of the person to which the person who vacated the office belonging and the person so appointment shall held. Person shall hold office for the remainder of the term of office of the member whose place to be appointment. Means if suppose vacancy is there for the last 6 months, nobody has the appointment, then the ministry will be immediately implement and they will be appointment the member. A member shall be disqualified being appointment as a member shall be removed from the membership from the central government if suppose this any allegation has been made by the member, any wrong thing has been done by the member, then immediately the step has been taken by the ministry, by the complaint, and immediately the removal will be there. A person shall be disqualified being appointed as a member has been convicted and sentenced for the imprison for the office which, in the opinion of the central government, involving moral turpitude in the undercharging insolvency. If of unsound mind and stand to be declared by the competent court or has been removed or dismissed from the service of the government or the body corporate owned controlled by the government. Has the opinion of central government financial and other interests of the bureau is likely to be affect prejudicially the discharge by him or his function as a member. Provided that no member shall be removed on the ground that he has become the subject of disqualification maintained in clause E, unless he has been given a reasonable opportunity being heard by the matter. Means if an allegation has been there, then a chance may be given to submit their allegation. Then afterward, the proceeding will be done. Proceeding of the government council. How the government council appointment in the Bureau of India Standard, that also be there. President or the absent vice president shall be present at the meeting of the government council, provided that in the absence of both the president and the vice president, member present at the meeting shall be elected from among themselves president over the meeting. At least one meeting of the government council shall be held every year, provided that the president may, at his direction, convey more than one meeting in a year if we consider if necessary. Notice of a not less than 21 days from the date of issue shall ordinarily be given member to each member of government council, provided that if it is necessary to convene an emergency meeting, a notice not less than 7 days shall be given to every member. The president shall be caused to be prepared and circulated to the member at least 7 days before the meeting. An agenda of the meeting, provided that the where the emergency meeting is convened and the agenda for such meeting may be circulated to the member at the meeting. 7 members shall be for the forum. I already told you 7 members there. Each member, including the president, shall have the one vote, and the call and the case of the unequality vote as any question to be decided by the government council, the president or the vice president of the member presiding over the such meeting shall be in addition have the casting vote. The proceeding of each meeting shall be circulated to each member of the government council, which shall be confirmed at the next meeting without a modification. Executive committee. Now it is executive committee. Executive committee shall be perform, exercise, and discharge how the function, power, and duty may be delegated to it by the government council. Government council is separate. Executive committee is separate. What are the function has been, any action has been taken, which is given to the executive committee. Then they have decided any term is there. Special Secretary or Additional Secretary, Financial Advisor of the Government of India, Ministry of Department, Administrative Control of the Bureau. Special Secretary, Additional Secretary, Government of India, Ministry of Department, Heavy Administrative Control Bureau. Joint Secretary of Government of India, Ministry of the Department, Heavy Administrative Control of the Bureau. 2 persons each represent different Ministry of Department, Central Government, other than Ministry of Department, Heavy Administrative Control of the Bureau. Secretary or Principal Secretary of the Department Administrative Control over industries or any state of Union Territory. Second, Secretary or Principal Secretary Department having the administrative control of consumer affairs, any state or territory rotation basis. 1 person represents consumer organization, 1 person represents industry trade their association, 2 person represents academic scientific research institute, 2 person represents public sector enterprise and technical professional organization. The member of executive committee appointment as Section 2 shall hold for the period 2 years for the eligibility. When a member of appointment under Section 2 desire to resign from the membership of the executive committee shall be forwarded later to resignation under this own Director General. Such resignation shall be take effect from the date of acceptance of Director General or the expiry of the period of 1 month from the date of receipt by the Director, which is earlier. The vacancy cause of the resignation, termination, etc. of the member of the executive committee shall be filled within a period of 3 months from the date of occurrence by the Bureau with the period of central government. I hope everybody be understanding. If nobody is understanding, please raise your hand so I can clear you whatever things are I'm telling you. I hope everybody is understanding. It is a basic thing of the Bureau of India standard, how they are functioning the work, who are appointed by the government, how the committees are there, what the committees are due. Then after, what next thing will become, what is the process of the BIS, how the license has been given, how the investigation has been made. Then after appeal is there, how the matter will be filed, how the appeal is will filed before the court. Proceeding, legal proceedings are there. Provided that the emergency meeting will be called, given not less than 3 days notice every member. Every notice of meeting executive committee shall be specified the place and the day and hour of the meeting. Tax officer chairman executive committee shall cause to be prepared and circulate to the member at least 7 days before the meeting and agenda for the meeting. Provide that where an emergency meeting is called, an agenda for the such meeting may be circulated to the member of the meeting. The forum for a meeting executive committee shall be 4. Proceeding of the each meeting shall be circulated to each member of the executive committee, which shall be confirmed to the next meeting with or without modification. Appointment of Director General. There shall be selected committee for the recommendation of the government of panel of the name for the appointment of Director General under Section 1 of Section 7. The selection committee shall be considered the following person, namely Secretary of the Government of India. Who is the Secretary of the Government of India, or the Chairman Department having administrative control of Bureau. Second, Secretary of the Government of India Department, they become the member, Science and Technology. Third, nominates of the Government of India Department, Personal Training, they become the member. And outside expert emergency from the relevant field, member of the nominated or central government selection committee shall be considered suitable candidate. Same thing is there, whatever I told you earlier. The qualification, the first class degree of engineering or technology of first class, postgraduate degree in the branch of science, means BIS doing for the engineers. All the engineers are working in the BIS. They have done the engineering. Engineering people are working in the BIS because it's the technical works are there for the purpose. engineering are be appointed by the BIs. All the scientists, director, scientists, assistant director, they are all are engineers. Explain that as at least 25 years of combination explain the following area in the government public undertaking of autonomous body or the private sector, namely industrial engineering, design, research, standardization, quality control, basic scientific technical research. In case of research experience in the laboratory, same should be national reputed and fifth administration. Provided that provided that candidate must be graduate degree in engineering or the directed of pure science and a batch of engineering having 20 years of experience and eligible. Also, anything contains section 3 of central government considered necessary may be public interest appointment, suitable officer, director general on the central traffic scheme as per the proceeding of the special that scheme. Term of the officer directors, director general. Director general shall have hold the office for the term of 3 years until the attainment of age of 60 years. Whichever is earlier, provided the term of director general may be extended to the central government for period not exceed the 2 years or until he be attained the age of 60 years, whichever is earlier, provided further that where the central government is certified that the reappointment of the outgoing directions, director general of he attained the age of 60 years, in his interest of bureau, he may be resigned to be recording writing appointment to him the further period not exceeding the 2 years. Now the establishment by India standard. Now what is BIS? That I'll tell you. The bureau shall be established in the standard relation in any goods, any article, process, system, or service shall reaffirm, amend, revise, or withdrawn. Then Indian standard is as so stabilized as may be necessary by a process of consultation with the stakeholder who may include representation of various interests such as consumer, regulatory, and other government body interesting testing laboratory or the collaboration of the laboratory, scientific technologies, and member of the committee of the bureau provided where a standard is being stabilized on the request of the central government or the regulator which is emerging from or has an impact of the national policy. The central government of the concerned regulatory shall be consulted to be ensured that the standard is constant with the such policy, provide further that any standard stabilized by the erstwhile Indian Standard Institute and the Bureau of Indian Standard stabilized under the Bureau of Standard Act 1986, bracket 63 or 1980 before the date of commencement of the Act or the rule of the regulation made thereunder, shall be deemed to have been stabilized under the provision of the Act or under this rule the regulation may be under section 39 of the Act. Clear all of you? What is the Bureau of Indian Standard? Any goods, articles, process, system, any manufacturing, any trading who was doing the IS packing, those suppose some job work has been done and packing has been done by some other person, but using ISA mark in the back, then without any license, then they also be culprit. If the investigation has been made, found that they will seize the PIs will seize the product and file the complaint against him before the court. Now some I'm seeing some others are joined. I can tell you there are, again I'm telling you the sections are there for the penalty 33, 14, 15, 6, 8, 2, 29 is for the in the penalty of earlier it is less than now it is maximum 5 lakh rupees is there. 17, 16 by 2. Appeal, if suppose somebody is going to appeal under section 13, bracket 4, 14, 17, 18, bracket 7, 27, 28. Here all of you, those who are joined later onwards. All India standard, their revision. These are the acts are there. Under this act, they are doing the BIS are doing the work. 20, 25 sections are there. 25, 30, minimum 30 sections are there. Under 30 sections, the BIS has done the work. Division council, the bureau shall be purpose of the formulation of India standard in respect to any goods. It has been divided. Division Council, Selection Committee. These all the things are there. I'll slowly you can be understand, and I'll define you properly. If nobody will understand, please raise your hand so I can come before you and explain you in other way. Please. So I will also enjoy to teach you, and you also will enjoy the subject. It is new subject for the students and for the professors and those who are working in the company. For their work, for their day-to-day work purpose of BSNL, they are also be useful for them. Division Council, the Bureau shall be for the purpose of formulation of Indian standard and export of any goods, article, process, system, or service, constitute technical committee.
We deeply apologize, sir.
Yeah, please.
Sir, we deeply apologize to interrupt you, but then can we please request you to be a bit slow, because there are many participants who are not able to follow.
Why is it not be clear? Can you repeat? Tell me the why is it not be clear here? Please again, if you tell me.
Yes, sir. Actually, the pace which you are taking is a bit fast for many participants to follow. So we would just like to request that can you be a little slow with your pace?
Okay. See, this what I told you. This is the basic thing that I will give you the PDF file also. You can read. There are the basic things are there of the BIS. How the BIS will be appointment. The committees has been formation. When the main issue will come, then I will very slow to tell you of all the things. These all the things are there, which is you can read in your home also. When I give you the PDF file, that also you understand how the committee will be forming. But the basic thing,
Sure,
what the basic thing is there, then I'll come very slow and slowly I will tell you what the things are there. Thank you, madam.
Sure,
Thank you.
Thank
I'll follow your instruction. Division Council, the Bureau shall be for the purpose of formulation of Indian standard in respect of any goods, article, process, system, or service, constitute technical committee of expert to be known as a Division Council. Selection Committee. The Division Council may constitute each such member of secretarial committee for the work of formulation of Indian standard as it will be considered necessary for the purpose. Every section committee shall be comprised of concerned officer of the Bureau and representative of the various interests such as consumer, regulatory, and other government body, industries, testing, organization, laboratories, or collaboration, laboratories, scientific technology, experts in the personal capacity and consumer interest, and an officer of the Bureau shall be member of Secretariat. Subcommittee, panel and working group. A scientific committee may be constituted such number of the subcommittee, panel of working group within the necessary, and it shall define their scope, composition, and coordination their activity. Term of the technical committee. The Division Council, sectional committee, and such committees shall be constituted once every 3 years, provided that the tenure of panels and working groups shall be decided by the concerned Division Council under which they were constituted. Division Council shall be constituted in defined area of industries, technologies, service, and other subject, and shall comprise of concerned officer of the Bureau and representative of the various interests such as the consumer, regulatory, and the office and the government bodies, industry, testing, laboratory, or collaborations, laboratory, scientists, and technology, and an officer of the Bureau shall be member secretary. The Division Council shall, 1, advise of the subject area to be taken up the formulation of the Indian standard, their respective area, keeping in view of national need and properties. Second, approval proposal of work and determine the priority to be assigned to the work. Direct the sectional committee concerned to undertake the work of the formulation of the standard. Advise on matters related to the research and development needed for the establishment of Indian standard of their revision. Study the work of the international organization and their committee in the standard formulation related to the area of work of the Division Council and recommended on the extent and manner of participations in standardization activity in the international level. Advise on implementation of stabilization standard and promotion of the Indian standard. Receive and deal with the activity, report and to make recommendation thereon to the government council concerning matter in which the decision of the government council is necessary. Carry out such tasks as may be specifically referred to it by the government council or the standard advisory committee constituted under clause C of subsection 1, section 5 and Act. See, if any amendment has to be made, if any inquiry has been made, any development has been there in the working or in the investigation, then when the committee will be there under section 5 or section 1C, they will implement and they will take action in that. Term of intending of the consultant. See, the BI is also engaging the consultant, also outsourced people. Bureau may be time to the engage. Sorry, Bureau may be time for the from the time to time engage such member of the consultant as may be considered necessary to assist the committee constituted under the rule. Second, the term and condition for the engaging consultant is the work of the technical committee, and in the work related to the stabilization of India standard shall be such as may be decided by the executive committee. Procedures for the establishment of India standard. Any person being a ministry of the central government, state. Procedure of the stabilization of India standard. How the India standard will be processed. Means BIS. Any person being a ministry of the central government, state government, unit territory, administration, consumer organization, industrial unit, industrial association, professional body, member of the government council, member of the technical committee, or any individual who propose for the establishment of India standard for the amending or for revising or withdrawing and establish under standard may be submit the proposal to Bureau in writing for the purpose. It is clear to all of you. If any grievance, any amendment have to be required. If any changes you want, you can be sent to give your application before the committee of the committee. Committee will be forward to the other department, and then after the amendment will be possibility, then it will be done. On receipt of the proposal under subsection 1, the Bureau shall be assigned the proposal of the council or council division. The division council are being satisfied at the result of its own deliberations or the investigation of the and consultations that the concerned interest in the necessity of the standardization has been stabilized shall be assigned the task of the formulations and the standard of selection committee constituted for the purpose. Provided that if the proposal of stabilizing India standard has not been accepted after the due consideration, the proposal shall be informed to the decision. The Indian standard prepared by the sectional committee shall be issued in draft from and widely circulated to the period not less than 1 month among the various interests concerned for the critical review of the suggestion for improvement of the provided that the wide circulation may be waived off if the selection committee is satisfied that the matter is urgent and non-controversial. If suppose first thing is that the immediate action has been taken by the committees also. If your grievance, any grievance is there related with the customer, related with the organization, such thing will be followed by him. Draft of India standard issue under section 4 be finalized by the council selection committee after giving due consideration of the committee of the comment, and that may be received, and the draft of so finalized shall be submitted to the chairman of the consult division council for adoption of the standard. Standard so adopt under subsection 5 shall be notified by the Bureau. Review of India standard means how to review. Review, what the meaning of review? means tenure review. Suppose any functions are there, some you are get any opportunity for doing the get a membership. Every 2 years you have to be renew. So such things has been done in Bureau of Indian Standard. The Bureau shall be reviewed practically at least once in 5 years. All established India standard to determine the need of or revision, amendment, reaffirmation, or withdrawal of such standard in the accordance with the provision of this rule. This understand all of you? Provide that the need for withdrawal of the establishment India standard shall be decided upon the respective division council on the recommendation of the sectional committee. Council provided further that the proposal related to the minor amendment in the nature of corrections of error or omission in stabilized under the India standard may be notified by the Bureau without reference to the concerned selection committee. Provided also that the Bureau shall have the power to provisionally aimed by notification such the provision of the India standard as in its view are necessary for expeditious fulfillment any of the objective of the act, and the amendment so made shall be regularized without further notification if the sectional committee council has to be on examination approved the standard as so amendment within a period of 6 months from the date of notification. Understand binding of certain cases. Save or otherwise provide section 2 of India standard are voluntary. Their implementation depends on adoption of the concerned party. An Indian standard shall be binding if it is separated in a contract or the referred in the legislation and made mandatory orders of the government. Publication. The Indian standard stabilized by the Bureau, their revision and the amendment shall be published and the copy thereof in any form as may be determined by the Bureau shall be made available for sale of the such price may be determined by the Bureau. Standard promotion. Sorry. Standard for promotions. The Bureau may be promote adoption of the Indian standard by consuming commerce industries, government and their interest in such a manner as may be considered necessary. Procedure for the establishment of the personal India standard. Where a proposal related to the new technology, respect of which this technical accuracy cannot be stabilized, the Bureau may be caused the division council to prepare a provisional India standard in accordance with the procedure of laid down under Rule 22. The provision of India standard or the paper under this rule shall be notified as the provision under India standard with wide circulations after its adoption by the chairman or division council concerned. Forward of the provision India standard shall be specified the following, namely, need for the paper of the provision India standard, scope of its application, period for its validity. Provided that the provision India standard so notified under subsection 2 shall be valid for a period up to 2 years as may be determined by the Bureau. On the recommendation of the sectional committee and may be extended for not more than 2 years. Clear all of you? If any doubt, please tell me. Don't be hesitate. Raise your hand. Definitely the organizer will be contact you and unplug you and you will ask with me anything. And those who are in the YouTube, they can send a message, SMS, whatever any query is there after the completing the webinar. We will discuss your questions, whatever your query is there. Provide India standard to be notified under section 2 shall be before the expiry of the validity period be examined by the consult section committee and establish it to regulate India standard. Provide that if the sectional committee, if on the opinion that such standard should be stabilized with or without modification or as a regular Indian standard, then the provision in the standard so notified shall be lapsed after its validity period. Concurrent running of India standard. Director General may be allowed concurrent running of two reason of the India standard, as may be also decide the period such concern running. Second, Director General may allow concurrent running of India standard at any of the amendments and may be also decided the period of such concurrent running. Adoption of other standard in India standard. That I'll clear you. You should not be doubt that. Now it not be clear. The Bureau may be in relation to any goods, article, process, system or service adopt any standard stabilized by any other institution in India, outside India, as an India standard is with the necessary modification in accordance with the procedure laid down in Rule 22, provide that any Indian standard adopted by the Spoil India Standard Institute and the Bureau of India Standard established under Bureau of India Standard Act 1986, Bracket 63 of 1986, shall be deemed to have been adopted under this provision of the Act, under this rule or the regulation under Section 39 of this Act. Second, standards so adopted India standard shall be notified by Bureau in official gazette notification. Recognition or accreditation of the institutions engaged in standardization. The term and condition for recognition and or accreditation of any institute in India or outside India engaged in the standardization shall be decided by the executive committee. Here, all of you, if any company is there, organizations are there, and the allegation has been made, then under this, they will conduct the investigation. Under Section 39, recognition of accreditation with the institute or engaged in standardization and the term of the condition of the institute in India is already standard mark. Standard mark shall be published by the Bureau of Official Gazette. Third, standard mark stabilized and notified by the Indian Standards Institute and the Bureau of India Standards stabilized under the Bureau of India Standard Act 1986, 1986 shall be deemed to be valid unless amendment for rescinded by the Bureau. Stabilization, maintenance, and recognition of laboratories. See, if any license has been given to you, or before license has been given by the BIS, there are the norms. Norms are there. Under that norms, they have to visit and verify the laboratory in the factory. The laboratory has done properly. Laboratory has been set up or not. If a laboratory has not been set up, the license will not be given. Proper laboratory must be required in the company, or in the any firm is there, any institute is there, or any organization is there, any factory is there. There, the laboratory must be required even the BIS given the license of ISMR and other norms, which are norms has been there in the list. They have to fulfill that also. The laboratory is established under the maintenance of the Bureau cell. Carry out the testing of the sample related to the conformity assignment scheme and Bureau C. The government department of the BIS, Bureau of India Standard, every 3 months or 6 months, they go to the concerned license holder to verify their details and collecting the samples and other things, which is be testing in the BIS laboratory. And then afterward, the confirmation has been given that the product is okay. Carry out research for the development, investigation, testing for the collecting data for involving any revision India standard for the quality assessment studios. See, if any complaint has been, they know about the complaint. There also they physically go for inspection, and afterward, after inspection, collecting the details, samples, and they will send for the testing purpose in their own laboratory. And after the verification of that, confirm that this is such and such a problem has there in that product. So that afterward they will be take the action against them. Provides support service to institute for quality improvement on such terms and conditions and be laid down by the Bureau time to time. In that, the amendment has been made, the act has been changes, such things are there. Time to time, any direction has been given by the department, time to time that is telling. Bureau may be recognized any laboratory in India, outside India for the carrying and testing of sample related to the conformity assignment and the such other functions of the bureau may be assigned to it. See, yeah, just hold on. I open the light, please, because properly you cannot see what I'm telling you. See, what those things are there. If suppose any BIS any raid somewhere, and after the raid they will collect the sample, or before raid, if they visit the market, also go outside, also done the investigation. In that, they will found that such thing is there, any doubt is there, then they collect the sample, and afterward they send to the department, and department send to the testing purpose. The inspection may be carried out in India, outside India, manufacture India at the place of manufacture before dispatch of at any place, enter into India or the place of sell out use in India. That also. Outside India also, they will contact the outside laboratory for the inspection purpose, or verification purpose, or testing purpose, and collecting the details for what the result is there. In India also, such thing has been there. If suppose their panel, in their panel laboratories are not there, then to invest to other laboratory people to collecting this thing. The fee for the inspection and the expenses incurred in traveling and other expenses related there shall be paid in the manner, and the rate may be specified bureau time to time. See, the officer who was going to time as per the government fee structure, they can get the TADA and everything. Now, the other question is coming. Appointment of the agent. They will appoint agent also. How they made the agent? BIS made the agent also. Who are the agent? How the agent has been made? How the agent has been appointment? What the procedures are there? And the bureau may be appoint any person or laboratory or organization in the India or outside India as an agent to act on its behalf for discharging any one or more of the following function, namely, see, in which case they will have a power to appoint the agent to carry out inspection. Suppose the department has not been positioned to go outside, or not be the less officers are there, and it is some other place which is not possible to go there, or the panel agents are there, then they will go and inspection and verify and submit the report before the PI's office. Then afterward, if suppose any negative report has been come, and afterward verification of the laboratory, they will found that the wrong work has been done, then immediately action has been taken against them. And then after the department officer will go and raid and seize, and then after take the action against him to test samples or product their conformity of India standard for the sample purpose also. To inspect consignment intended to be covered under the standard mark or under certificate of conformity, to collect market samples and to carry out market surveillance and survey for any goods, articles, process, system, and service. Clear, all of you? See, agent have the same duty what the government officer has been, PS officer is doing, same thing done by the agent who was the agent in that place, area, in nearby place. They have to be follow same way which way the BIS is doing the work. The term and condition of appointment shall be set out in the agreement between the Bureau of India Standard and the agent's so appointment. There the format of their of India, under that format, the agent has to be work under the department, under the term and condition. Provide that the appointment of agent outside India shall be made with the preview approval by the central government. See, if any outside India the agent has been appointed, then the director of the BIS have to give the application to the ministry. After the ministry approval has been given, then after the appointment has been confirmed in abroad. inspection of goods, articles, system and service when the standard mark or conformity of India standard is required by the act under any other law. This is a one question under other law. The Bureau may be carry out inspection through its certification officer or the agent or a goods articles process system or service where the standard mark or conformity of India standard is required to be claimed under the act. Clear, all of you? The inspection may be carried out in India, outside India, or before the dispatch, or at the place of its entry into India, or at its of its sell or use in India. The inspection may be include the inspection may be include inspections of quality control system or verification of the record or testing of the sample, any other related matter that also done by the BIS. The fee for the inspection and the expensive income covering this all that are done already I tell you. Provision of the to publish, reproduce, to record authorizing of the Bureau. Other point. Other point is their provision to publish, reproduce, or record without authorizing by the Bureau. If it has been given using, then the criminal offense has been lodged against them. Without the authorization of the Bureau, any man reproduce or record any standard or point document under that create and maybe create the impression that if the is so contained an Indian standard as contemplated in this act, provide that nothing this subsection shall be prevent any individual from making a copy of Indian standard is personal use. This have to be followed. Otherwise, it will be restricted, ban on the license has been cancelled. Conformity, other point, conformity assessment scheme. The Bureau may be notified or specify or different conformity assessment scheme for any goods, article, process, system or service, or for a group of goods, article, process, system or service. And the case may be with respect of any Indian standard in any other standard in a manner as may be specified by the regulations. Second point. The Bureau may be stabilized a standard mark in relation to each of its conformity assessment scheme, which shall be on such design and contain such particulars as may be specified by regulation to represent a particular standard. Clear, all of you? Any question, please? Next point, grant of license or certified of conformity. How the license has been given, license after the, you can, all the term and condition what has been given you have fulfilled. Then afterward license has been given of the, what is the amount has been fixed for the depositing of the charge. A person may be apply for the grant, what happened? What happened?
Sir, please share the screen again. There's some problem with Zoom.
Where the problem is arising in my
Zoom
side
section, yes.
Oh.
Yes. Sir.
Okay.
No, sir. No, sir. No. That's
Okay.
problem, sir.
Right.
Really sorry, sir.
Where I'm, how the license has been given? What the process are there? Committee as may be if the good article process system service conform to an India standard. Where any goods article process system or service conform to a standard, the director may by an agent or grant a certificate of the conformity in a manner as may be specified by the regulations. License to use to apply standard mark in a manner as may be specified by regulation, subject to such condition and on payment of such fees, include the late fee or fine before or during the operations of the certificate of the conformity of the license and as determined by regulations. Means what are the formalities are there? I show you the format, what the format is there in the later onward, under which format the application has been given, and term conditions are there which has not been related, have not been attached. It can be find out in the online also how the term conditions are there, the BIS for the taking the license. The term conditions are there. The factory have to be laboratory must be required, and the Factory Act, the registration Factory Act registration must be there. Under the Factory Act, the system are done properly, neatly. A number of the points are there in that such thing has been completed, and afterward the BIS, the fees or the fees for the registration purpose is submitted. Then the license has been given, or late fee also, if you submitted late, the late fee also be there. Under late fee you submitted your application for the license purpose. After the clear physical, the department physical inspection has been did, submit the report also, other details also be collected, then afterward license has been given. Next, certification of standard mark of jewelry and seller of certain specific goods or articles. Number of cases are coming of such thing. Day to day in the court, the water illegally ISI mark has been small, has been done in the package, in the water package and in the pouch. Such things have been coming. And if the jewelry also cases are coming before the metro in the magistrate first class in the lower court related with the procedures. The central government, after the considering of bureau, may not be because of metals, even other goods or articles may be considered necessary to be marked as the case may be in a manner specified subsection 2. The good or article notified subsection 1 may be sold through the retail outlet certified by the bureau after such goods or articles have been assessed for the conformity of to the relevant standard by the testing and making center recognized by the bureau and marked with the hallmark of the standard mark as case may be specified by the regulation. See, in the BIS they given the hallmark for the gold purpose, and for the general they will give the ISI mark. Bureau may be an order, grant, renew, suspend, cancel, verification, standard mark or hallmark or of a jewelry, any seller or the sale of goods or articles notified under subsection 1 of such manner as may be determined by the regulation. See, the license has been given. When they cannot be fulfilled, later on, if suppose they found that the work has been not been done properly and the details which have been submitting to the department is not being done properly, or renew has been not been made. Number of cases of coming of the renew. The renew has not been done. And they have using the ISI. There also has been made found that the renew has been done, action has been taken. Such cases are coming before the lower metropolitan magistrate. Next, 5. Bureau may be stabilize, maintain, and recognize testing and making center, including the SSCI, and make center for the conformity assessment and the application of the standard mark, including hallmark of the goods of the article notified under subsection 1 in a manner may specify regulations. Same thing. It have to be informed. Goods will be inspection has been there, sent to the laboratory also to the verification of person. No testing and making center or assessing hallmark center other than the recognized by the bureau shall be respect to the goods of articles not notified under subsection 1 use effects impose invert, print, or apply in any manner of the standard mark, including the mark or the colorable imitations thereof on any goods or articles, and make any claims in relation to the use and application of the standard mark, including the hallmark through advertising sales. Promotion, lifters, price list, or the like. Every recognition, testing and marking center, including SYing and heel marking center, shall use to apply standard mark on goods or articles notified under sub-rule subsection 1, including hallmark on precious metal articles, after accurately determining the conformity of the same as manner may be specified. Clear, all of you? See, for the hallmark purpose, the laboratory is not be there. They will send some other places for the inspection purpose, for the for taking the details of purpose. No recognition can include SY and marking center shall be not sending that it has been recognized under subsection 5, used to apply to any goods or articles under subsection A, standard mark, including the hallmark, any color implied thereof. Who is writing something in there? Please.
Whosoever is doing this, be clear, we will not entertain your...
When I'm writing this thing?
So,
delete this thing. Why necessary disturbing me when I'm taking your telling to all of you? No person shall be.
This is completely unacceptable from your participants. Really.
No person shall be imposed, disturb, shall be stored or exhibited for sell any goods or articles. Subsection 1, section 50, except under qualification from the Bureau. It is provision for the import, sell, and exhibit. There's a provision. No such thing will be done in the open market. No person shall be import, distribute, sell, store, or exhibit for sell any goods or articles under subsection 1, section 14, except under certification from the Bureau. No person other than that that's certified by the Bureau shall sell or display or offer to sell goods or articles that are notified under subsection 3, section 14, and marked with the standard mark, including hallmark, and claimed in relation to the standard mark, including hallmark through advertisement, self-promotion, lifter price list, like such things are there. Without license, they cannot be used such thing in the sell exhibition. This is properly be banned to such thing. Such good articles in market with the standard hallmark in a manner may be specified by regulation, and unless such goods or article conform to the relevant standard. Central government to direct compulsory use of standard mark. If the central government is of the opinion that it is necessary or expected so to do in the public interest for the protection of human, animals, and plant health, safety of the environment, or prevention of unfair trade practice, of the national security, it may, after the consulting of the Bureau, by an order published in the official gazette, notify purpose, system or service. Which the goods, article, system or service which shall be conformed to a standard and direct the use of the standard mark under a license or certificate of conformity as the compulsory on such goods, article, process, system. For the purpose of this subsection, the presence scheduled industries shall have the meaning assigned to it in the Industry Development and Regulation Act 1951, bracket 65 of 1951. It is hereby clarified that the essential requirement expressed in the term of the perimeter to be achieved or requirement of the standard in technical terms that effectively ensure that any goods, articles, process, system, or service meet the objective of health, safety, and environment. The central government may, by an order, authorize Bureau of any other agency having necessary accreditation or recognition and valid approval of the certified and the enforced conformity to the relevant standard or prescribed essential requirement under this section 1. Provision of to manufacture, sell, etc. certain goods without standard mark. Without ISI mark cannot be, they will be used. No person shall be manufacture, import, distribute, sell, here, lease, store, or exhibit for sale only such goods, article, pro system, or service under subsection 1 of section 16. Without a standard mark except under valid license. First. Second, notwithstanding that he has been granted a license, applied the standard mark under such goods, article, process, system, or service conform to the relevant standard or the prescribed essential requirements. No person shall be, third, no person shall be publicly through the advertisement, sales promotion, lifted price list, or the like that his goods, articles, process, system, or service conform to an Indian standard or mark such a declaration on the goods or articles without having a valid certificates of conformity license from any other approval by the central government under subsection 2 or 6 of section 16. 3. No person shall be used, apply for the purpose of use to apply in any manner in the manufacture, distribution, sale, heirs, lease, or exhibit of offer for the sale of any goods of articles, process, system, or service in the titles of any patent or in any trademark or design or the standard mark of any colorable intimation thereof, the expert under the valid license from Bureau. Obligation of the license holder, seller, etc. The license holder shall at all times remain responsible for the conformity of the goods, articles, process, system, or service carrying the standard mark. It shall be responsibility for the distribution of the seller as the case may be to ensure that the goods, articles, process, system, service carrying the standard mark are purchased from certificate body or license holder. C. One more thing, requested to all participants and other organizations, those who are listen later onward by YouTube or in this channel, I requested to all of you, if you purchasing any item, any product from the market, you can verify ISI mark. Some of the company, they not use ISI mark. That means the company is not properly manufacturing the product. The product which has been in the market, it has been not be properly, their infrastructure has not been properly made. So that's why ISI mark has been not be given to them and not be taken by these people, these people. So I requesting all of you participants, you can also pass the message to all your colleagues, friends. If suppose ISI marks had not been there, then nobody can be used such type of the product, because such type of product can be not be done, made properly, not be infrastructure has not been properly, the product has been not be manufactured properly, not be the product quality was not be good. So that's why I requested to all of you. Second, the goods, article, process, system, service carrying the standard mark bear the required labels and marking details as specified by the Bureau for time to time. They have to put the mark, label, everything at time to time. Date also have to be there before if they're manufacturing and using ISI mark. ISI mark, stamp, ISI stamp. The marking and the labeling requirement for the product or covering is displaying in a manner that has been specified by the Bureau. Fourth, every certified body or license holder shall supply to the Bureau with such information and with the such symbols of any materials or substance used in relation to any goods, article, process, system, or service as the case may be, as the bureau may be required for the monitoring its quality and for the recovery for the fee as may be prescribed in the certified by or conformity of the license. 5. The bureau may be make such inspection and takes a sample of any materials or such substance as may be necessary to see whether any goods, article, process, system or service in relation to which the standard mark has been used conform to the requirement of the relevant standard, or whether the standard mark has been properly used in relation to any of goods, article, process, system, service or without a license. It is not being used using without the license. Same thing I told you, same thing has been written in this paragraph. I told you this paragraph. Second paragraph. The point. The bureau may be published in the result of finding out the direction from the pursuance thereof. If the bureau certify under provision section 4 and 5 that the goods, article, process, system or service relation to which the standard mark has been used do not conform to the requirement of the relevant standard, the bureau may be direct the certified body or license holder or his representative to stop the supply and sell the non-conform goods or articles. Recall the non-conformist goods and articles that have already been supplied or effort for the sales and bear such marks from the market or any such place from where they are likely to be effort for the sales or provision to provide the service. Clear to all of you? If suppose the license has been told to the client, to the customer, not to the manufacturer, to stop the supplying before the market and seal the product and given the notice to them, it won't be used as ISMI license and don't be sell in the market. Whatever sells, all the materials will be take back and keep in your factory. You have put down whatever thing. Second term also they come and verify the inspection if they have all the materials has been taken back or not. Then after seal the factory also sometime. Where license body or license holder represents sold goods, article, process, system or service without bear the standard mark or any tolerable imitations thereof and do not conform to the relevant standard, the bureau shall be direct certified body, a license holder or representative. A repair or replace, reprocess the standard mark goods, article, process, system, service manner as may be specified. As per the term and conditions, they have to be made it, specified it there. Pay compensation to the consumer as may be specified by the bureau. All the term and condition has been made for the customer purpose, consumer purpose also. Be liable for the injury caused or non-conforming goods or articles which bear standard mark as per provision 31. This under 31, the provision they have to follow their consumer term and condition which is given by the BIS. They have to follow the term condition when they made a relation with the customers. Office by the companies. When an office under this act has been committed by a company, even director, manager, secretary, or other officer of the company who at the time the offense was committed was in charge of was responsible for to the company for the conduct of the business of the company or authorized representative for the company as will be company shall be deemed to be guilty of the offense and shall be liable to be proceeded against the punished accordingly, irrespective of the fact that the offense has been committed with or without the consent of or convenience of or is attributable and any neglect any part of the direction, manager, secretary, or office of the company, authorized representative of the company. If the company has taken that, the such thing has to be followed by the company also. Explanation is there for the purpose of this section. Company means the body corporate into the form other association with the individual. And direction in relation to form means a partner of the firm. Now the other point, compensation of non-conforming goods. Compensation will also be given by the department if suppose such thing is there. where a holder license is certified for the conformity of his representative sold any goods, article, process, system, or service with the bears of the standard mark not conforming to the relevant standard, or with the colorable intimations, the consumer intimations, the certified body of license holder of the representation shall be labeled to compensate the consumer to be injury caused by such non-conformity, goods, article, process, system, or service, such manner as be prescribed. Offered by the court. What are the cognizance shall be taken against the person who is not be comply or not be properly done the term and condition when taking the license afterward. No court inferior to the metropolitan magistrate or judicial magistrate first class specifically on behalf of the Office Punishment Act. Matter will file before the judicial magistrate first class. All matter will file in the lower court in judicial magistrate first class, not in inferior to the judicial magistrate. The first class judicial magistrate must have to be power to take the matter. No court shall be cognizant in any offence punished under this act. The other court have to no jurisdiction. First class magistrate have the power. Same thing telling them. Under the authority of the bureau, any police officer not below the rank of deputy superintendent of the police equivalent. If any inspection has been taken, the deputy of the police have to be inspection under the police. The complaint has been registered before. An authority notified under section 2 or section 16. Any offence imposed under this authority of the government. Any consumer, any association. These all the things are there. Though matter will file complaint against them. Then the department will take the action. Any police officer not below the rank of deputy superintendent police or equivalent to me, he be satisfied that any of the offence referred to subsection 3, section 29 is being or is likely to be committed, seize or search and seize without a warrant the goods, die, block, machine, plates, other instruments or thing involved in committing the offence wherever found, and in the articles of the so seize shall be soon be practicable to produce before the magistrate as prescribed under section 1. Whatever the seized items are there, whenever the trial will be conducted, then after the time of the trial, before it has been submitted before the court. The Muddamal. Whatever the is taken has been taken, which has been submitted through the police and or through the advocate or the panel lawyer to submit before the court. The court may be directed that the property in respect with the contraventions has been taken place shall be forfeited to the bureau. Second point, the court may be directed that any fine the whole in any part thereof payable under the provision of this act shall be payable by the bureau. Compounding and the offence is all now under this offence of the criminal code of criminal proceeding 1972-74. Under that, the proceeding will be filed before the court. First class punishment committed for the first time. The punishment under this act being an offence punishment with imprisonment only, or imprisonment with the and also with the fine maybe before the after the institution of any prosecution be accompanied by an officer so authorized by the Director General in the such manner may be prescribed, provide that the such so specified shall not be any case exceed minimum amount will fine which may be imposed under section 29 for the offence so compounded if any second or subsequent offence committed after the expiry period of 3 years for date which that offence was previously compounded shall be deemed to be offence committed for the first time. See, this new section has been implemented in that the department will be also be conducted the matter. Director General. In that, something has been written. If some first time will be there, then the third time, second time has been made, then afterward, section 29 take the legal action against, and 5 lakhs have to be period of 3 years, 5 lakh also be imposed in such cases. Every officer referred to subsection 1 shall exercise the power to compound the offence subject to direction, control, and supervision of the bureau. Point. Every application of the compoundant of the offence shall be made in such a manner as may be prescribed. Third point, where any offence is compounded before the institution and any prosecution, no prosecution shall be instituted in relation with such offence against the offender in relation to whom the offence is so compounded. Other point, wherein a composition of any offence is made after the institution, any prosecution, such composition shall be brought to the notice of the court in which the prosecution is pending in writing by the officer referred to in subsection 1, and on the such notice or the composition of the offence being given and in the accepted by the court, the person against whom the offence is so compound shall be discharged. Other function of the bureau. Now this has been made. Other function of the bureau may be formulated, implemented, already activity in relation to the quality, maintenance and improvement of the production process. B, promoted harmonious development in standardization, management, and conformity, assessment, and matter connected therewith, both within the country and international level. C, provided information, documentation, other service to consumers and consumer organization on such terms and conditions may be mutually agreed upon. Give recognition to the quality assurance system in manufacturing or processing unit of service providers on such terms and conditions as may be mutually agreed upon. Bring out handbooks, guides, and other special publications to help to the customers. Carry out inspection, testing of goods, articles, or audit of the process system service for conformity of any other standard if so authorizing, and such term and conditions may be mutually agreed upon. Clear all of you? Any query is there, please? Next, formulated implementations and coordinating activity or conformity assessment to the relevant India standard or voluntary or compulsory basic of goods and articles process system or service as may be considered expedient in the public interest. Time to time, they have taken such steps to assist the license holder and for the public purpose also. Provision as the restriction of use certain names. One point is there. Provision as to restriction to use certain names. Any person using any name, mark or trademark, etc., referred in the subsection 1 of section 26 of the Act, who is not obtained previous approval of the Bureau of such use shall, if such name, mark or trademark, etc., has been stabilized to the Bureau for permission to the use thereof within a period of 6 months from dedication to this group, Bureau may be grant permission such name, mark or trademark, etc. What I am telling, if any person has taken the trademark license, in that they have to be, trademark department have to be informed to the BIS also. And with a 6-month BIS department has the inspection and the follow, then after the clearance has given to the trademark, then after trademark department give the license, trademark registration number will be given to them. Other before that, it not be possible to give the registration number. So this is the section 26 of the BIS. Under this section, the trademark department have to be follow this the instruction of this section and instruction and section that they have to be informed to the BIS department related with if any case is there. Second point of this, no testing and making center for the assessing or hallmark center other than the recognition by the Bureau shall with respect of goods or articles notify under subsection 1 use, effects, impose, engraves, print, or apply of any manner of standard mark, including the hallmark or correlable imitations thereof, if any goods or articles, and make any claims in relation to the use of an application of the standard mark, including the hallmark through that advertisement, sales and promoted, lifters, price list, and the like. These all the things are there under this they have to be followed under section 26. Every recognized testing and marking center, including assessing and hallmarking centers, shall use or apply standard marks or standard articles notified under section 1, including articles or previous mental articles after accurately determining the conformity of the scheme may be specified. Clear, all of you? Next point. No recognized testing and the marking center, including assessing and hallmarking center, shall be notwithstanding that it has been recognized under subsection. Second point. Use the applied relation to any goods or articles notified under subsection 1. A standard mark including hallmark, any colorable imitations thereof, unless such goods or article conform to the relevant standards. Provision of the import cell exhibit etc. is already I told you. Central government to direct compulsory use standard mark. If the central government is of the opinion that it is necessary to or expedient so to do in public interest for the purpose of protection of the human animals, health, safety, environment, prevention of infective practice, necessary security service, consent guru may be prescribed in the office basic notification. Appeal against decision of the bureau. If suppose the order has been passed, the appeal has been filed before the High Court. Any person aggrieved by the order made under section 13 or section 4 or section 14 or section 17 of the Act may be appealed to Director General within 90 days of the date of order. Okay, fine. If such order is there, appeal before the BIS, you can file to Director General before under this section. Appeal. Suppose order has been passed by the BIS, then you can move before the appeal to the Director General related with that. And also court also, you can move before the court also. Provided that if the applicant certifies the Director General that he had the sufficient cause for not deferring the appeal within the period so specified, appeal may be admitted after the expiration of the said period of 90 days. The delay also may be if your ground is there for the delay has been made, but you have a ground clear before the Director General that such as my ground is there for that purpose I cannot be appear before the you. So please grant the delay. So delay may be also be granted. Every appeal made under section 1 shall be filed in duplicate and shall be complied with the self-attested copy order applied against. See, when you file in the DG, this in the Director General, okay, the application, then in the two set you have to give you and the order copy. With the order copy with other medication, in the two set you have to give to the Director General. Every appeal section sub rule 1 of 2,000 rupees in form and the demand draft pay in order e-transfer down in the favor of bureau. The registration fee of 2,000 rupees also be there, which have to pay by you through the by e-transfer in the department, BA department. The Director General will call for the relief as he consider necessary and after an opportunity to the party such order as he think fit. See, when you give in the under section 17, 16, before the DG, 17, 18, 14, 27, before the DG, then the population, if you will be ask you if your any other details have to be submitted before him, you can be submit. If your any details are there, you can submit. After he will scrutinize and he will found that if it is reliable or it is be under the BI Act, if any other point will be find out by the DG, then he will think fit. He will pass the order. Order will be disposed of within a period of 90 days from date of filing. In DG, within 90 days, matter can be filed before the DG. may sort of is an application from specify the bureau time to time review and reconsider any order passed under subsection under sub rule 4. An officer to whom the power have been delegated by whom any may confirm, modified or set aside the order passed by such officer and after the review. Clear all of you? Any person agree with the article order passed by the Director General under sub rule 4.5 as the case may be, may prefer an appeal for the central government in the ministry having administered control of the bureau within a period of 60 days from the date of order. See, I'm reading again. You can be what I point is there. Please understand. Any person agree an order passed by the DG Director General under sub rule 4.5 as the case may be, may prefer an appeal to the central government in the ministry having administrative control of the bureau within period of 60 days from date of such order. Clear all of you? The provision of sub rule 2, sub rule 4 shall apply mutatis to every appeal filed under section sub rule 6. Certification officers. Other point. Every certificate of officer appointment under section 27 of the Act shall be furnished by the Bureau with a certificate of the appointment as may be certification of it in the form as specified by the Bureau time to time. Second point, the certificate shall be carried by the certificate officer at all times while he is on duty and shall be deemed to produce by him. Third point, every application for the license or a certificate for conformity holder of the license or certificate of conformity shall be afforded to the certification officer. Such resembles facility as the certification of the duties imposed on him by order of the Act or of the certificate officer without prejudice of the power conforming under section 27 of the Act. This may be at any time the usual power of certificate officer. What is the power of certificate officer? Under section 28, they will do at any time during enter upon the any premises which will be any goods, article, process, system, service, in respect of which the license certificates of the conformation has been granted with the view to assent that the standard mark is being used in accordance with the term and condition imposed by the and that scheme and testing specified by the Bureau as being correctly followed. Second point, the inspect and take samples of such premises or any such goods or articles of any materials used or intended to be used in the manufacturing of such goods or articles which is marked with trademark. Third point is inspect and process system or service such premises in respect of which the certified body of license holder has been granted a license. Third point, examine the record kept by the certified body or license holder relating to the certificate of conformity use of standard mark. See any such good or document which is relevant any proceeding under this Act under this rule. This is have to be followed by the officer of the compensation of non-conformation of goods. Other parts of the thing. Where certificate body license holder is representative and he has sold goods, articles, process, system of service with the bearer standard mark of any colorful imitation thereof, he is not conform to relevant standard, and where the Bureau decided that the certificate body a license holder of his representative shall pay compass under clause B, subsection 7 or section 18 of the Act, then the compensation payable in such case shall be 2 times and selling price of the non-conformation goods, article, process, system of the service and the testing charge provided the basic of shortage of purity for the rate of such articles sold as testing charge. Clear all of you? This is telling that if suppose standard marks has been taken, then after time to time they have to follow rules and regulation, and time to time they do the testing work. Cleared all of you? Now, second point, every application of the company shall be made and formed specified by the Bureau time to time to the self copy of the relevant documents include the test report of the goods, article, process, system, service in question relevant to stabilize non-conformancy. Test report shall be issued by any laboratory maintained or recognized by the Bureau. Third point, the head of the regional officer of the Bureau under whose jurisdiction holder the license, a certificate of the conformity fail shall be authority competent or to decide the compensation provided that the authority shall decide the application within 60 days of its filing. Provide further that before passing any order using subsection and the opportunity to file the statement defense shall be afforded to the holder of the license, certificate of the conformity whom the application is related, and opportunity personal hearing may also be given both the side if the circumstances be deserved. If the case holder of the license, the certificate of conformity fails or refuses to pay the amount of the compensation as provided under this rule within a period of the 30 days from date of passing of the order, Bureau may be cancelled the license certificate of conformity. Clear, all of you? See, this is the process of the BIS. Under this process, what I'm telling you, under this process, they are not be complied. The license will be cancelled. The renew has not been done. The test has been not been done. So such points are there. I'm telling you, you can be heard properly. If any question is there, please tell me. Or after completing the webinar, then after you tell me. If non-conformance standard stabilized by Bureau will be carried out inspection of the simple samples of product of the market in the productions of the site and the intimation further action against the license as per the license condition. Where the Bureau decided that a certified body of license holder of the representative is liable for injury cause of non-conformance of good of articles under clause C of subsection 718 of the Act, it shall be communicated of this decision to the certified body of license holder of his representative, and the certified body of the license holder of his representative shall take a decision of the compensation under Article 31 of the Act with the period of 2 months of the receipt of such communications. Now, 70 penalty for the contraventions. What the penalty will be there? Now, the license will be taken by the other commodity with the gold. How the director has been appointment. This all the things have been told by me. Now the other penalty, how the penalty has been incurred in the before the court, how the section will be filed before under section matter has been taken. Any person for the contravention of provision under section 11, section 1, and section 26 shall be punished with a fine which may extend to 5 lakh rupees. Earlier it said less. Now the government has amended. Now it has been 5 lakh. So take precaution when you're using ISI mark. Have made a proper term and rule regulation. Follow the rule regulation. If ISI mark is not used, otherwise what happens? Sometimes I have the BIS lawyer. Sometimes what happens? Because the 5 lakh impose is not possible to the such of the people. They are crying before the court and then telling that we are poor people, we have no money, 5 lakh rupees, and we have taken the money from interest from the outside people. So please bear to us, please help to us. Such thing they are crying before the court and before to me also. So take precaution, such thing. Don't be used without ISA mark, without ISA license, without ISA hallmark, or if suppose such thing ISA marks are there with the customer, with the factory, then they will follow the term, condition, rule, regulation of the BIS. It's my request to all of you. Any person with the convention subsection 6 and 8 of the section 14 and 15 shall be punished with imprisonment with term which may extend to 1 year and fine which shall be not less than 1 lakh rupees but may be extended to 5 times the value of the goods and articles product or sold, offered or sold, effects apply standard in the mark, hallmark or both, provided there the value of the goods, articles, product sold, offered to be sold cannot be determined. It shall be presumed that the 1 year's production will be such contravention and the annual turnover of the previous financial year shall be taken by the value of good articles for such contraventions. Second, third, any shall be punished with imprisonment with a term which may be extended up to 2 years, or with the fine which shall be not be less than 2 lakhs rupees. First contravention will not be less than 5 lakh rupees. Second and subsequently contravention but may be extended up to 10 times. And the value of good article produced to be sold or offered to be sold or affects to operate with standard mark, including the hallmark of both provided the value the goods or articles produced or sold or offered to be sold cannot be determined. It shall be presumed that a 1 year's production within such contravention and the annual turnover in the previous financial year shall be taken as a value of goods of articles such contraventions. The offence under section 3 will be cognizable. Offence, now the second point is offence by the company. If the company has offence, this act has been committed under this act 17, 16, 29, where an offence under this act has been committed by a company, every director, manager, secretary, other officer of the company who at the time of offence was committed was in charge and was responsible of the company for the conduct of business of the company or the authorized representative of the company deemed to be guilty of that shall liable without consent of the conveyance of or the eligible of any neglect on the part of the any director, manager, secretary, or any officer of the company or authorized representative of the company. Understand? Clear? Not be clear? Again, I'm telling you. If any company is there, an inspection has been made, and in that inspection found that there is the company officer who's working also be liable, and other officer also be liable, and director also be liable in this case. And all will be punished if suppose amount has been not be paid by you up to 5 lakh rupees. So such have to be followed by you. If you're doing any mistake, don't do such type of mistake. Next point, compensation non-conforming goods. Compensation for not conforming goods. Where a holder of license a certificate of conformity of his representative has sold any goods, article, process, system or service which bear of standard marks not conforming to the relevant standard or with the colorable imitations, the certified body of a license holder of his representation shall be liable to be compensated the consumer for the injury caused. Such non-conformation goods, article, process, system, service, such manner may be prescribed. Clear all of you? Second point, cognizance of the offence by the court. No court are inferior to that magistrate of the first class power to be and try to under this act. No court shall be, I tell you already this. Amount of the offence. Automatically completed section 73, offence committed the first time, that also I told you. Compounded under offence. Any offence committed the first time punishable under this act may be either before, after the instituted, maybe prosecution become by the office of that. General shall be authorized to writing head to the regional officer. See, if any complaint has been made against you, any order has passed, you be going director regional. How can you go? How you can go? आप कैसे जाएंगे डीजी के पास अपना कंप्लेंट लेके कैसे जाएंगे वो मैं आपको क्लियर करता हूँ. Provided that Director General shall authorized in writing head to the regional office or any other senior officer below equal rank to the council after the institution to completion of the offence specified section 33 of the Act. On receipt of the application under subsection 2, compounding authority shall call for a report from the concerned branch officer with reference to the particular furnished in the application of any other information which may be considered relevant for the examination of such application, and for the report shall be furnished by the branch officer within 30 days within extended may be allowed by the compounding authority from the date of receipt of the communication from compounding authority. Second point, the compounding authority, after giving personal hearing to the applicant and after taking into account of the content of the said application, may be order giving the reasonable or arriving at the decision, either allow the application indication of the compounding amount or reject such application, provided that the application shall not be rejected unless an appointing has been given to the applicant or being heard, and for the ground such rejecting and maintained to such order. Provide that the applicant shall not be claimed as the matter right that the offence is compounded. Provide further that the no compound shall be allowed by the compounding authority where there is a apparent contracted inconstitutions or the incompetence of the case appointment. A copy of order passed by under sub rule 4 shall be sent to the application and post or email of application also given place in the bureau. Where the prosecution has already been instituted, the compounding authority being composition, including the compounding amount, to the notice of the court by filing appropriate application and shall be bound by the decision of the court and such application. The application shall be period of 30 days from the date of receipt of the order of sub rule 4, allowing the compounding officer offense an order of the court under subsection C. 6. Pay to the Bureau of Compounding paid by the compounding authority to the court as the case may be, and shall furnish the proof of such payment to the compounding authority, provided for the compounding amount once paid shall be refundable, not be refundable, except the case where the court reject grant immunity for the prosecution of the same offence. Amount of compound under this rule shall be provided the following table. Tables are there that you will supply the PDF you can see. Subsection 1, section 29, 50% of maximum, subject a minimum 25% of the applicable fine. Subsection 2, section 29, 50% of maximum of subject maximum 1 lakh rupees of payable fine. Subsection 3, section 29, 50% of maximum and subject to the minimum of the 2 lakh rupees if the person had committed offense falling under more than one or category specified tables have sub rule 8, amount of the compounding subsection shall be amount determining for the offense where the higher compounding amount has been prescribed. The power of the duty compound authority. The compounding authority, if you certify that any person has been made an application for compounding an offense under sub rule 2, rule 50 has been operative in the proceeding before him and is made full and true disclose of the fact relating to the goods, article, process, systems or service, grant such person immunity from the prosecution under this act if the prosecution has been instituted with the respect of the case to compounded, subject to such condition as the compounding authority may be fined if it imposed. Compounding authority shall be individuals to decide whether application is compounded within 60 days of its filing. The compounding authority shall be filed before the Director General a monthly report indicating the details application received by him, action thereon. Clear all of you? Now the license purpose, if anybody will be give, this is a license purpose, minister. The format is there. You can see in how the application is there. Now I'm telling about the judgments are there. Judgments are there. One judgment of Delhi High Court is there. Under that, Bureau of India Standard were party allowed to appeal, and the matter has been favor of the BPL, BIS, Pepsi India, Hilco Private Limited. The matter has been filed against him regarding that 6-month fine. So for that purpose, so matter has been favor of BIS. Same thing as there in the against matter before Justice Ravinder Bhatt and Justice R.B. Vesar, Justice S.P. Ravinder Bhatt, open court. The transfer purpose of the BIS cases are there, which has been rejected by the High Court and favor to the BIS. One more thing, sir, Lakshmi and other Bureau of India Standard, criminal case number 5411 of 2014. There also such thing is there. The trial may be conducted to other place which has been also related, and sentence of 2,000 rupees penalty is there that also will be given to the BIS and matter has been dismissed. Thanks to all of you participants to participate. I hope you all enjoy that. If any query is there, any question is there, please be with the all the committee members. They will be contact you very soon.
Thank you so much, sir, for such an informative
Yeah,
session.
please.
Yes, we have
Can
some
you
questions from
loudly
the
tell, because
participants.
your voice is very slow, please, if you don't mind.
Yes, for sure, sir. Now is the voice audible?
Yeah, it is there. Please proceed.
Yeah. Yes, sir. Sir, the main question, or there are many other questions, but some of them are like, if any seller made a fraud by selling the item without BIS mark, however, he has the BIS mark in his possession, then to whom the buyer should approach regarding such fraud?
See, if information and get to the BIS officer or BIS department, then immediately the BIS department with the consent of the police officer, taking the police officer with them, an officer, they will raid the concerned factory premises. And after the investigation, they will found that the illegal activity is going on. Without a license, ISI mark is there, hallmark is there. Immediately they will seize all the products and immediately take the action against them, and they will file before the police also and file the matter before the court also. Clear, all of you? And if anybody have to take the license, then you go before the BIS office, consult BI office. The format is there also. I am sending you, and the proper format is there. The term condition, everything is there. You can say all the norms, what are the norms are there. Under the norm, they will come after the fees is there, registration fee is there. After the confirmation, everything, they will issue the license. Clear? All clear? Next, Apurva, please.
Yes, sir. The next question is like, can any product contain fake ISI mark? And if yes,
take your voice is again very hard. Please.
yes, sir.
Please,
Yes,
not
sir.
is okay. Yeah.
Can any product contain fake ISI mark? And if yes, then how to identify the same?
See, if suppose any company is there, if suppose Ponds company is there, Ponds, I say, if Ponds company is there, get the Ponds information that some wrong product has been manufacturing and using ISI mark, and ISI mark department also get the information against it. Then immediately it will be raided to the concerned department, police department also. They will see the police also be come with the BIS, given the application to the BIS. Police also will be there. Then after the seize all the items and product, and then afterward legal proceeding will be there. Clear?
Yes, sir. Thank you so much, sir. Then we move towards the last question for the session. Though we have some more questions, but as we are
No problem.
lacking
Tell,
time.
no problem. If I'm free, please tell me. I'm also enjoying here. I'm also enjoying it. When somebody asking me, because I have rich experience in the subject, so I must take more interest if suppose somebody will ask anything. Please.
Thank you so much, sir. Another question goes like, while lodging a complaint, what information should be given by the customer?
Any complaint, please repeat.
While someone is lodging a complaint, so what specific information should someone give regarding that offense?
Where the complaint has been given to the department, or where the complaint has been given, it is adequate misunderstanding. See, I'll tell you, if some number of times what happened, outsources people also be coming and complain to the BS department, Bureau of Interest department, that this person had doing the wrong thing. Then after BS department is sending his officer to verify if suppose such thing is there or not. Verification afterward, they confirm if such thing is there, then they take the step. In this process, where the person has complained, that the question in the police or in the BS department, that have to be different is there. If the police had complaint has been, then the police also be come to the BS department or to contact to the BS department. Then after BS department also take one party with the police in this way. In other way, direct BS department, the BS department direct interfere in the subject. Clear?
Yes, sir.
Please, madam.
Thank you so much, sir, for your answering our questions, and thank you so much for such an informative session. Now, if
All the questions are there. Give my email address to all of them. If any question they does not understanding, I can clear them. So they will
thank you so much, sir. While we'll send them the feedback form, we'll forward the same email so that they can ask you the questions. Please. And now I forward to Ms. Chandrika Semwal, the founder of Legal Patra, to deliver the vote of thanks.
Yeah, Chandrika madam, please proceed.
Thank you so much, sir, for the webinar.
Thank you, Chandrika.
And thank you everyone
Thank you all
thank you everyone for delivering such a wonderful lecture on BIS. And we are very thankful to you for explaining the whole act in a short span of time.
Thank you all of you. I see just now lockdown period is there. Only morning 2 hours we are doing the court work, and after we are free. So all the students of the college, they are getting some benefit from our senior advocate, from me. I am very pleased to give my experience, to share my experience with the juniors and with the students.
Thank you, sir, and we look forward for more webinars with you. And thank you so much,
please,
sir.
Please. Thank you all of you. Thank you.
And to all the participants, we are organizing one another webinar on Consumer Protection Act on 14th of August. Kindly participate on that. Thank you.
And for the participants who had more questions but couldn't be answered, we'll surely be forwarding you sir's email ID. Then you can forward your questions and can seek answers from the same. Thank you so much for being such a patient audience. Thank you so much, and we look forward for more collaboration. Thank you so much, sir.